fundamental difference that the MTC doesn't seem to appreciate and that these states don't seem to appreciate between the Wayfair context and Public Law 272 is the source of the rule. And it's one thing for the Supreme Court to say, we created a rule in 1992. Now we're in 2018. Yeah, we don't like our rule as much as we did then. I mean, you can, or the composition of our court has changed sufficiently so that we no longer have 5 votes in favor of that rule. But regardless, I mean, I know Justice Kennedy was the swing vote and he changed his mind. But at most, that's the U.S. Supreme Court saying, under difference, a rule that we made is no longer viable under the current system. And all that did was open the door to states to engage in their own legislation under an economic nexus standard. And if they do that, and if it's clear enough, then we may grumble, but we have rules to follow. But to suggest that Congress, through an affirmative act in 1959, did something relating to e-commerce is frankly absurd. And I do not think that the composition of the current court would be receptive to an argument that, given their predilection for interpretations that relate to, well, business activities means what it meant in 1959, not what it might mean in 2018. And I do think that whatever frustrations the MTC and its membership and the states may have, that's something they need to take up with Congress if they want to change the rules.